one important thing, we have been talking about the word forthwith, and apparently it only appears in our Constitution, not in the U.S. Constitution, which our Constitution was patterned off. So I was
So
just
who put that in? Who put in that word?
Maybe Commissioner Sarmiento had
Yeah,
some input.
He talked about it, and I think the feedback was that from Commissioner Sarmiento was that there really was an intent on the part of the Constitutional
framers.
Commission, the framers, to ensure that there would be no undue delay in the trial and in impeachment proceedings. You have to go back to the history of the Marcos era impeachment, where in the first Marcos administration, where there were so many procedural hurdles that Marcos allies were able to use to defeat impeachment complaints during martial law, immediately after martial law. So the framers thought of lowering the required number of votes to convict, lowering the required number of votes to impeach, and probably included forthwith as well in order to tell Congress to speed up the proceeding.
When it comes to forthwith, and going back to, I think we touched on this earlier, some say there's an amount of reasonableness that goes with the as soon as possible message of the word forthwith, right? Meaning the reasonable means the schedule, the predetermined recesses, etc., etc. Because we are divided, people, right, are divided about that. How do you think it's going to fall, honestly? Because it's now up to the Senate gauging, right, Filipinos' reactions, our feelings, and which side we're on, and what we are inclined to pick if we were the senators. I think that's kind of their mindset, and trying to read our minds. Your thoughts?
I think that, in terms of interpreting forthwith, the Senate would be motivated by reasons outside of the law. And that's not unconstitutional or wrong at all. Right? Again, the Constitution gives them a lot of leeway to decide to interpret these provisions. I think on the whole, accountability requires that they move quickly. But there's also a recognition that this is a political process. And therefore, and it's conceded by the speakers of the second panel that we had, who are the counsels for the House and Vice President Duterte, that the people get a say in this proceeding.
Yeah.
So insofar as the Senate is biding its time to gauge public opinion, that might be a valid reason, in my opinion, but there's a limit to that. Because you can never really know public opinion short of an election. And because the Vice President is not up for election, then any result from the upcoming elections would be speculation as to whether it's really driven by support of the Vice President or something else, or the sheer popularity of the candidates.
Yeah, well, Professor, since we're talking about the timeline, let's say this does happen in the 20th Congress, with SP Escudero saying it might be taken up after the SONA in July already, meaning there are already a new set of senators, new Congress members. What's the validity of that? I mean, help us understand, because you've also got some groups saying, some critics saying, it's not valid because they'd be having a fresh mandate. The senators will also, you have got new senators elected already, so it's not the same 12 that was in the 19th Congress.
So this was one of the questions that the panel was also split on, because I think they weren't sure about, or nobody's really sure about whether the Senate would still have the authority to continue. So there are two views currently. One view says that the Senate would get to continue because, as Senate President Rilon pointed out, or his view is that the Senate is an independent, the impeachment court transcends the Senate. And therefore it can continue even if the present Senate goes away and a new one is elected in the coming election. I think the other view, and that's really an accountability view, right? The idea that you should hold the Vice President accountable and therefore it should transcend the typical end of the term of the Senate. The other view is founded more on a democratic view of the Constitution, in the sense that, or the impeachment process, in the sense that when elections happen in May, that reflects a popular choice to elect different people. And that choice, or the choice of the people who will succeed the current Senate, should not be bound by the past Senate's decisions on whether to proceed to trial or not. So again, the jury is out. And if the question really is, so what's going to happen? it's the Senate again who gets to decide.
So I was going to say, who gets to pick? So it's
I
still
think
the
all
Senate.
the questions will
Still
be
the
answered,
Senate.
only be answered by the Senate.
The Senate will throw out the hypothesis, and then it's the rest of the branches of government and political actors will contest that hypothesis, and ultimately but ultimately it's the Senate who gets a first crack at this.
Let's
I was
get to the
checking-
third question.
No, before we move there, just one quickly, because this was interesting. I was talking to Attorney Tamase earlier in the holding area, and I asked, okay, so if the 19th Senate moves and they decide on the rules for this impeachment, will the 20th Congress be bound by the rules of the 19th Congress? And his answer was,
No, they can get to decide their own rules. The Senate is not bound by the rules of a previous Senate. Of course, that raises all sorts of questions about typically
About the case, like, do you
Yeah.
start over?
and
Yes.
does the the impeached official, right, is her due process rights violated by that sudden change in rules? So it opens up a lot of questions if it crosses over to June 30.